Okay, good afternoon, everyone. My name is Ruby Ramirez, and on behalf of the Fresno Area Hispanic Foundation, we would like to say thank you for joining us for today's presentation. Before getting started, I want to share a quick tutorial on using the chat box tools. If you are accessing the webinar using a laptop, you can simply click on the chat box chat icon of your screen. If you are using a tablet, please select the participant icon, and on the left side, you will see the chat feature. If accessing through a mobile device, please tap the More option on your screen to access the chat feature. Please send us your questions throughout the presentation. I also want to remind you that all participants will receive a copy of this webinar recording. I would like to recognize the following sponsors that allow our organization to provide these weekly webinars to our business community. Thank you to Bank of America, Bank of the West, Chevron, Federal Home Loan Bank of San Francisco, Donna G. Sales, Wells Fargo, Tri-Counties Bank, JP Morgan Chase & Co., and Union Bank for your support. Here's the agenda for today's presentation. Welcome remarks by myself here. And the presentation will be given by William or Bill Kell, who is the clinic director of the New Business Community Law Clinic. And then after the presentation, we will have a live Q&A session with the clinic attorneys and law students. I would like to share with you about the Fresno Area Hispanic Foundation. We are a nonprofit organization in the Central Valley with a mission to promote education and self-sufficiency by fostering entrepreneurship. At this time, our team is providing the following core programs remotely to our community: our virtual technical assistance, our weekly webinars, and microloan programs. At this moment, we are also collaborating with the County of Fresno to provide $250,000 in grants of $5,000 to small businesses in the County of Fresno that have been impacted by COVID-19. Applications and eligibility criteria for grant program is currently available on the FAHF website, which is on the flyer there, fresnoahf.org. The deadline to apply for the County of Fresno grant will be September 29th of 2020, which is coming up this Tuesday. And if you need assistance to fill out the application, we do have representatives who speak English, Spanish, Hmong, and Punjabi. You can simply call us at 559-222-8705.
Oh, thank you.
Can you guys see my screen there?
Little younger photos there, but
Okay, at this moment, I would like to introduce our speaker for today, Bill Kell, who is the clinic director for the New Business Community Law Clinic at Berkeley Law. Welcome, Bill.
Thank you very much. And I'm joined today also by student Rafael Grillo Villa, who's going to be doing the presentation with me. There you go, Rafael. Hello.
Okay.
Yeah, please say hello. Good. Yeah. All right, folks, let's see. Let's get right to it. Do some share screen. Is that okay with everyone? Yep, yep. Here we go. All right, oops, go back to the first slide and from the beginning. Yeah, great. Can everybody see that?
Yes.
Yes.
Everybody see that? Good. And so we're going to try and blitz through this as quickly as we can. And I do encourage you to use the chat function to ask your questions. Desiree LaFleur will be monitoring the chat, and we'll turn to those questions in order as they at the end of the session. And Desiree may try to answer some of them as we go along.
And if you want to ask it more privately within there, just direct message me on the chat feature, and I will not out your name.
There you go. That's a good idea. All right, everyone. Well, tough time, difficult time to be hiring people, but glad that you might be hiring people during COVID-19 because so many people, you know, are out of work at this point, trying to find a way to get by. Hopefully this workshop will give you some sense of how, you know, what your responsibilities are as an employer, both generally and then also specifically during COVID-19. So here's our agenda for today. The big takeaway we want you to go with is this idea that there are three types of workers, essentially: the employees, the independent contractors, and the volunteers or the unpaid workers that you might hire at some point. We call these the three buckets to think of. And the reason for the distinction between them is that they all have very important legal requirements that go with them, and you can't really sort of be halfway in a bucket or not. It's the state of California, the feds also see these buckets as very distinct. And in this workshop, we're also going to be giving you some sense of AB 5, which was also updated recently with AB 2557. Which has presented some challenges for employers trying to use contracting labor, and also for the self-employed who are trying to be contractors. So we're going to cover a few things about that. And then we want you to know some things about COVID-related laws that employers have to follow, both in terms of employee leave policies and workplace safety measures. So let's get right into it right now. Raphael, please take it away.
Sure, thank you, Bill. So as Bill said, it's very important to make sure that you have your employees or your workers, to be specific, into any of the three buckets, which is employees, independent contractors, and then unpaid workers, which are interns or volunteers. As Bill said, the law sees this as three very clear, distinct type of workers. And there are many reasons that people go in to help work, especially with startups. Roles are very ambiguous. It's very unclear as to who's doing what or for why. But if any type of issue comes up, if you end up in court, or if there is some sort of analysis that the government needs to do, they're going to want to categorize the people you're working with into one of these three categories. So that's why it's important to make sure that that is clarified from the start. So again, this is why fluid relationships, sometimes they're useful from a business perspective, but from a legal perspective, it's a little bit of a red flag. So the government, when they look at the categorizations, if it's not clear to them where they fall in, they will try to classify it for you. And most often than not, they will find that the worker that you're working with is an employee. And that is a type of relationship that has the most requirements that go with it. And we'll be going into those requirements shortly, but the biggest issue is if it's unclear and the government wants to categorize something for you, they'll put it as an employee, and it may be that you are not doing these things that you were supposed to be doing with employees, and that could be an issue down the road. So we want to make sure that we categorize these appropriately. And speaking of employees, the first category we'll go into. So what are the requirements behind employees? There's a whole checklist that we will be covering shortly, but the basics of, first of all, onboarding an employee is you have to make sure that there was an application for somebody to apply to be an employee of your company, that there was an interview, that you actually checked references and use the usual employment processes, right, that some of us are familiar with. We receive the offer letter, we get supervised as employees. You want to make sure you're providing that to your employees. And there's a set of personnel policies that you can check the link that we may be able to send around later, but basically there's a set of best practices that you can follow. Anything else, Bill?
No, that's good. I should mention, sometimes we pitch for something called HR California, which is put out by the Chamber of Commerce. It's a subscription service, very helpful service for employment law questions and such. You actually can, type them a question and have an employment attorney answer it. It's not cheap. It's $200 or $300 a year, but it is a good backstop for employers to get their hands on the laws, on an immediate basis if they need it.
Good point. So speaking of that 17-point checklist to make sure we're treating our employees correctly, the first thing for those of us who have been employees, and we always see those payroll tax deductions on our side, well, now you're going to be in charge of all of that. So you got to make sure that you have, well, first of all, before all that, make sure you have an employer identification number so that the government kind of knows who they're working with. Register yourself with the California Employment Development Department, and these are all links you can use to do that. And then you got to start withholding those federal and state income taxes, as well as the Social Security payments that need to be made. So you'll want to make sure you have the system set up to do all that. There are some payroll services that you can look into later, but the buck stops with you in terms of making sure that that is set up somehow. And you also want to make sure that you're also withholding any type of payments that need to be made for disability insurance or any other type of insurance. And speaking of other types of insurance, some of the other ones you need to keep track of: workers' compensation, any type of unemployment insurance. In terms of payroll taxes, there may also be local city payroll taxes that you may need to keep track of. On top of all those taxes, you want to make sure that you have a federal I-9 completed for all your employees and that you report all of these employees to the EDD. So another thing you need to make sure that you also do in terms of forms to keep track of, you want to make sure that on top of the I-9, you have the W-4 and the state forms required, such as the DE-4 for each employee, and that you also notify employees of any types of rights or things they may be entitled to or may have access to, like the earned income credit. You also need to make sure that if you have any type of notices that you have to provide your employees, you give it to them. And the usual, you want to make sure that your employees, you're treating them well, you're treating them in accordance to the safety laws and the non-discrimination laws that are in place in the federal, state level. And I think that's, oh, sorry.
Yeah, no, that's good. I was going to mention there is usually a big poster that you need to get to put up at your workplace. Now, if people are working at home, you actually have to send this information to them. It's basically an overview of workplace, mostly workplace safety, but also rights that they have. If you need to find this poster, just let us know and we can send you the link for it. So a couple of things to think about in terms of specific laws here that we've already mentioned. Of course, you need to follow California minimum wage law. As of now, it's $12 an hour for employers with 25 employees or less. $13 an hour for employers with 26 employees or more. Now, you should know that that's statewide. Now, that can be upped by local law. So, for example, there is a Berkeley minimum wage law. There's a San Francisco minimum wage law. And of course, the California minimum wage law is actually higher than the federal minimum wage law. And so the employees get the benefit of the highest sort of wage law that is on the books for them. And a couple of things to know about in terms of hours for non-exempt employees. So these are employees that don't actually manage other people. There's a few other distinguishing factors of what are exempt versus non-exempt employees. But essentially any employees not involved in management, you have to be looking at how many hours they're doing a week, or assuming a day, 8 hours a day. More than 8 hours a day in a 40-hour week means overtime. Overtime is 1.5 times the base pay. More than 12 hours in one day is 2 times the base pay. And then you have to pay attention to breaks. Now, breaks is an area where there could be some, important, risk management you need to do, because you are on the hook to show that the employees actually got the breaks. And didn't just sort of work all the way through it, and then end of the day they didn't get their breaks. Those saved up over time are things that it's sue about. And so just know that the lunch break is has to be 30 minutes. It cannot start later than the 6th hour. Let's see, during that time you have to relieve employees of all duties. They can't be like answering the phones or watching the door or something. They actually have to be told responsibilities for that time. Rest breaks, again, depends on the number of hours worked, but these are breaks that have to be worked in. And the best thing to do about this is to get your employees sort of checking each other about it. I've seen a number of times going to the grocery store where I'm in cashier's there, and then some cashier comes up to her and says, "Hey, time for your break." And the person says, "Well, I'm just going to finish up." "No, it's time for your break." And so that means you don't have to keep track of it quite so much if you sort of build that into the culture. Now, there are some federal employment laws that apply here, but they don't apply to all businesses. They apply to employment workplaces according to the number of employees that they have. Okay, so there are a few things that all employers have to do, like child labor laws, disability insurance, workplace safety type stuff, but then there are certain ones that only kick in when you're getting up into 15 or 20 more employees. So we just want to make sure that you got this little chart, which is very helpful. Actually, this chart I got from HR California, that service I was talking about. But look at all these that are all applicable to all employers, okay? Like sexual harassment, how independent contractors are treated, paid family leave. There's that poster you got to put up. All employers have to put those up, not just by size. And then, you know, a few other things: unemployment insurance, wage and hour, workers' comp. These are all things that all employers have to work with. So how do you keep track of all this stuff? Yeah, look at that person there. That's probably how you feel. Well, fortunately, there are people that will help you do this. So, you know, if you like accounting, well, gee, do it yourself. But instead, we highly recommend using accountants for such things, payroll services like paychecks or benefits. You should just know that these are deductible business expenses to you. So, you know, and helpful for your peace of mind as well, for sure. So now I'm going to talk a little bit about independent contractors, which is really shaped by AB 5 in the state of California and this new update 257, AB 2557. So what you know is that in 2019, California passed this law, which, and I should say, it created a new standard. It really, courts say, and the legislature says this, well, this was always the standard. Well, it wasn't quite always the standard, but now it is. So it's this thing called the ABC test. Now, you would hope that ABC would stand for something like an acronym, like A is for something, but no, it's just a 3-part test that they decided to call the ABC test. So, well, anyway, so what is A? A is really what has been always the traditional test, which is independent contractors should pretty much be able to control the manner and means of the work that they do, you know, free from the hiring entity's control. And I'll go into each of these in a minute, but let's go to the next one. B is the one, by the way, referred to as the killer bee for Uber and Lyft. Independent contractors cannot be used to provide the regular services of the business. So for example, you are a childcare center. Your teachers should be employees. And thus, if you're Uber, your drivers should be employees. Now they're trying to exempt this under a state referendum that I guess is not doing so well right now. But you know, generally the idea is if you're advertising certain services, the people providing those services need to be employees. And finally, independent contractors need to be in business for themselves. This is another aspect that Uber had some trouble with, which is, you know, it would be okay if these drivers also were like limo drivers driving for other people, but instead they're really beholden just to Uber for what they're doing. I suppose some drive for Uber and Lyft like that. But the main thing is that it shouldn't be that the independent contractor is has only one person that they're working for. Okay. All right. So now a couple of things you should know in terms of exemptions. Here under AB 5 and new AB 2557, all of these professions are exempted from the independent contractor requirements. So the main thing with that is you just got to not control them very much is the problem. And that's good because you should know that right after AB 5 was passed, man, a lot of things happened, like freelance writers, for example. The Chronicle, San Francisco Chronicle wouldn't hire freelance writers anymore. I mean, think of how many hundreds of years newspapers work with contracted journalists, you know, for this period of time until the 6 came along, you know, newspapers and others were reluctant to hire people as contractors because of potential risks, which we'll get into later there. But here are all these other specifically exempted workers under AB 5. Now there is another category here. Now this is helpful, you should know, for people who are trying to be employed as well, okay? because there's this exception called business to business contracting, okay? So if you can show that you are hiring somebody, but they are basically a business of themselves, and as I mentioned earlier, are working for other people and stuff, okay, well, that's an exemption in and of itself there. So what does this mean for self-employed people? This means that, yeah, maybe you've been sole proprietors up until now, but if you really want to get back into the contracting game, you need to set yourself up as a business. And what I mean by that is usually form an entity for yourself, market yourself as being available for work with a lot of people, put that on your website and stuff. And you know, generally show that you are what's called an independent business and then providing services to business. Of course, you could, you know, if you set up this this independent business status for yourself, you could work for individuals as well. I'm just saying that under AB5, there's a specific exception for business to business contracting. Now there's this Borello test that you have to pass, which I'll show you in just a second. It's essentially a control test. It's essentially saying, look, if you're hiring a business to business contractor, yeah, you can't stand over them, tell them they have to come into your office 8 hours a day, use your materials, wear your uniform. You can't do stuff like that. Instead, you give them a project, like a marketing plan you want them to develop for you, or a website you want them to develop for you. Give them the parameters of that marketing plan, a little bit of what you want to see on your website, but you generally leave them to do the decision making, do the work on their own time with their own materials there. You should know that professional service workers, that's like us, like attorneys, these folks are also exempted from AB5 as long as they pass that Borello test. So for example, you know, I could be a contractor to somebody as an attorney, but again, they can't tell me what to do, and they shouldn't be telling me what to do unless they're an attorney, of course. But the idea is that I have a business, I have a license, which I would use in my business there. And, you know, oh, here's another aspect of showing that you're an independent business, have a business license. Go put in a DBA form in your local county there, of course. But ability to set their own hours. And here's that Borello test that I was talking about. Generally, the way you pass this test is by being free from the hiring entity's control. And, you know, a few other factors to think about. Well, how long are the services going to be performed? Are we talking about years here? That situation, maybe you're talking more like an employee there. Let's see, certainly the intentions of the people hiring there, if they're intending to create an employer-employee relationship matter, but that's not controlling in some fashion. Here's an important part. The skill required in the particular occupation is not something that the business itself has. So that's another good example. A plumber, you know, do you have to have a plumber on your employee staff all the time? No, you can hire that person if they have skills that you don't have on a, you know, now and then basis to come in and fix your, you know, stopped up drain. Now, why is this all important? These risks for employers right now? Well, you see, it used to be that the California Employment Department and the Labor Commissioner's Office and the Franchise Tax Board had authority to review potential misclassification of workers. But AB5 now gives that right to sue and sue for misclassification to not only the California Attorney General, city attorneys, and local prosecutors, but most importantly, individuals can employ their own attorneys to bring you to court. And you would be subject to a 4-year statute of limitations. This is something that's very concerning to people, is that 3 years from now, well, 3.95 years from now, people could come back and say, you know, I just think I should have been classified as an employee rather than an independent contractor. And they could get an attorney, they could have the attorney's fees paid by you if you lose, and then all that past wages and penalties on all that. So it's pretty big risk for people about this misclassification. All right, so our overall recommendation contractors are, of course, only utilize independent contractors when the workers will meet the ABC test or are exempt. We do definitely recommend that you put things in writing with them. And then, you know, allow them as much autonomy as you can. Here's an important thing: make sure they get some liability insurance, and also make sure that whatever they're creating for you in terms of intellectual property is actually assigned to you afterwards. So that person who made that website for you, make sure that in the agreement with them, they agree to assign it to you. Otherwise, the default is that they continue to own it, and maybe they'll just give you a license for doing it there. And then, of course, you know, treat these folks as employees when they don't meet the ABC test or fit into that exception. So Raphael, yeah.
Unpaid workers, the favorite part of a student, because we always get those unpaid internship solicitations. They're trickier than they seem at first. So there's a lot of risk if you're offering some sort of unpaid position, call it unpaid internship, volunteering, what have you. At the end of the day, it's an unpaid worker. So there's some misunderstandings when, if you put an advertisement of like an unpaid internship, some people might have expectation that they're going to get hired later, or they might get some sort of compensation at the end of the day. And you have to be clear that that's not the case, and that also creates some issues. There's also some lack of clarity in terms of who owns the product of what the interns create, and there's always the possibility of liability down the road. This is especially true if you're trying to take on a volunteer or an unpaid intern as a for-profit. If you're doing it as part of a partnership, an LLC, a corporation, any type that's for-profit, that's not something that's a nonprofit organization, that's going to have a lot of rules around it, and we can go over those.
So nonprofits, you should know, are just generally, it's okay to use volunteers. It's just a few things you should spell out in a contract. Those things about any work product they create or intellectual property, yes, they should be assigning that to you. They should probably say in the contract also that they are working for you without expectation of payment.
That's a great point. Expectations are always key. And for an unpaid internship, you want to make sure, especially if you're like a for-profit, you want to make sure that the training that you do, whatever sort of internship or volunteer position you're offering, it's similar to what would actually be given in school, and that it's something that's primarily to the benefit, and that is actually completely for the benefit of the trainee or the student. If somehow this student or this trainee, this unpaid worker, is displacing regular workers, if it's under close supervision, if you're driving any type of immediate benefit from actually getting this volunteer or this trainee or student, then the employer is actually, you're taking on some risk there. So you have to make clear, and in your practice, you have to make sure that this type of unpaid work is for the benefit of the trainee. Now, you also have to make clear, as always, clarity is key, as Bill said, like, you have to make sure that you make clear that this intern, this unpaid worker, is not necessarily entitled to a job at the end, and he's not necessarily entitled to wages at any time. And there's some ways to kind of cover some of these issues. You could probably set it up as some sort, this unpaid internship as some sort of school program, but generally speaking, we'd probably recommend that the requirements are probably more issues than they're worth. So you want to make sure that you keep that in mind. And always good practice, make sure you get any type of arrangement in writing.
Absolutely. And you may be able to set up some credit with like a local community college or city college or something like that. That also helps create some record that this had something to do with learning going forward. Okay, well, good. Well, let's cover a few things about COVID-19 requirements for employers. A couple of things to think about. First of all, I can't see, I'm afraid the top is a little covered up here. Let's see if I can put this down. Can I move this thing? Move that over. There we go. Oh, there we go. Yes, so these are new employee leave policies that the feds passed just at the beginning of the virus. And here's another thing that you might want to post up on your wall about paid leave and unpaid leave. So you just got to know that employees get paid sick leave at 100% pay up to 80 hours. Now, it's unfortunately people go through that pretty quickly. That you also need to allow employees 12 weeks of paid sick leave, okay? And give up to 10 more weeks of paid expanded family and medical leave. Again, a portion of the pay of the employees paid during this period of time. This is continuing. This is not going away very soon. But I guess what I'd say to you is probably most employees have already exhausted this since the beginning of the pandemic. It's just something that everybody's got to pay attention to at this time for trying to help workers, especially with people sick at home or maybe sick themselves. Now, if they're sick themselves, of course, they take their sick leave. If they continue to be sick beyond the amount of sick leave that they have, then you might want to think in terms of like the ADA, sort of disability, treat it more like a disability, and then needing some accommodation at work, or an accommodation could be working from home, or having some time off, or working fewer hours or stuff like that. Another thing, oops, come on, where's my next slide here? Come on, here we go. Now, another thing to think about is, well, what about potential transmission? What about workers suing me because I wasn't careful enough in setting up the workplace under my responsibilities to create a safe workplace for my employees, given the potential transmission with COVID-19. So here's the headline for you. You need to develop a plan around this. Under state law, under what's called Cal OSHA, this is called an infectious disease preparedness and response plan, or whatever you call it, the IDPR. But what it means is you have taken into account sort of the level of exposure that your workers will potentially have with vis-a-vis each other, vis-a-vis customers, and put this into some kind of plan that will diminish the risk of infection. And so, of course, first thing you gotta do is develop this plan. We'll tell you what should go in a second. But you want to train your employees in all aspects of the plan. And here's really, really important. Keep good records of the plan and your compliance efforts with the plan. Why do I say that? It's because the first thing that most employers are asking us these days is, well, how do I avoid getting sued? How do I avoid getting sued? It's very hard to avoid getting sued because any fool can sue you. The thing you can do is to show how careful you have been, so that a suit against you is going to just not likely be successful, is the idea. All right. So let me say a few things about what oops, there's our plan. My animation went a little funny there. So here's what you potentially think about in your IDPR, your disease preparedness response plan. Okay, you should know that actually under state law, you should already have this thing called the Injury and Illness Prevention Program, or the IIPP. It's actually required under state law for basically every employer, okay? But here's which factors you want to consider in your IDPR plan. You want to think about this exposure risk for your workers, from customers, from members of the public generally, from coworkers, from sick individuals generally. So for example, if somebody is at work and they come down with symptoms, then you got to be thinking in terms of isolating that person until they can get to medical care or get home, right? You also have to be thinking about, okay, well, our workers do go home. What about if they got exposed at home or got exposed in the community and then brought that back into the workplace? Okay, and you have to be thinking about the workers' individual risk factors. I mean, I myself, I have diabetes, so that's a big risk. I'm also 61, so that's another risk potentially to be thinking about for your employees. So if you have somebody in like my work categories, my particular risk categories, you might assign them, more of the back area away from the customers and such. So you need to also be planning in this plan for contingencies such as more people out of work, interrupted supply chains and deliveries. Some different ways you could deal with this would be, of course, you got to work in that social distancing, maybe staggering work shifts so that people aren't sort of on top of each other all the time. Certainly make sure that there's remote service delivery, that people just, deliver stuff. You don't actually have to go out and get it potentially there. And what we do recommend is, if you have a workforce that was very sort of, how would I say it, specialized, certain people doing specialized things, well, because there's potentially going to be more absenteeism, make sure that you do some training to help people maybe back other people up on things. I'm not saying that somebody who's not skilled in accounting should be doing your accounting, but maybe take that accountant who could maybe also answer some phones or work the counter and let them do that sometimes when other people are out, right? Okay, so here are these basic infection prevention measures that all employers need to be thinking about. Requiring, and this is, again, this is for people, businesses that have contact with the public. All right, I'm not talking about potential, work at home kind of situation. You're selling things out of your home. Yeah, you don't have to wear a mask when you're at home. I'm just saying that. But if there is any contact with customers, yeah, you need to be putting in the masks. You need to be putting on the masks, working in the social distancing, the hand washing, and then of course the training in your plan that you put out here or there. Of course, encourage your workers to cough or sneeze in their own elbows, not somebody else's elbow. And make sure that they're self-monitoring and reporting symptoms to you. So if they feel sick during the day, yeah, that is something that's not supposed to be a secret. That's something they need to come to you about. And you should be encouraging them to stay home if they're sick. And in fact, you should probably be encouraging them to stay home if a family member is sick. Why? Because it's very likely that person is going to be bringing it into the office. So find some ways for them to work at home and care for their sick family member at the same time. Of course, provide tissues, trash cans. People can throw things away, wipe their hands and stuff, lots of disinfecting, that isolation of different sick individuals. And here's a couple of things to think about. Do not allow workers to be sharing tools without wiping them down, or spaces without wiping them down. And here's one other thing to note is normally maybe you used to require if somebody was sick that they needed a doctor's note. No, don't require a doctor's note if they're absent, because that could just allow them to get infected there at the doctor's office. Instead, find some way to, have them have some proof, that they describe for you over email, and then worry about whether they're making it up later. But the idea is that what OSHA says is that informed workers who feel safe at work are less likely to be unnecessarily absent. That means if they see that you're doing all this stuff here, they're going to be more likely to stick with it and not sort of say, well, I was sort of feeling bad today because I don't want to come into work and get COVID. That's so again, if you're taking these measures here, you're showing them how careful you're being, and it's just going to be safer for people all around. Now, here's one last thing I wanted to flag for you, and that is that if people are working from home for you, you are still actually required to create a safe workplace for them within your ability to control it, okay? So, for example, send those workplace policies posters home to each employee so they just know what their rights are and things like that. You should know that I-9 forms, those forms that are showing that you have the legal right to work in the US, employers used to have employees come in and actually give them these forms and sign these forms and the documentation in person, but that's no longer required. It's okay to do that through email or video now. Here's another part. Employers must reimburse for remote employees reasonable and necessary expenses. So if they need internet to work from home, if they need a specialized chair, that they had at work with this, to help their back, you need to make sure they have one at home. Yes. One of our supervising attorneys is in the Dominican Republic right now. And so we needed to pay for an upgrade of her internet so that she could continue to work like this. Now, there could continue to be some issues with harassment, even when people working at home. I mean, you got to imagine that people are, brought into your living room. And so if your living room includes, some objectionable posters or things like that, or, people walking by in the background with no clothes on or stuff like that, that could be harassment for people, if they're having to work via Zoom. You know, you have to police that a little bit. You have to tell people, hey, look, cover up a little bit during our staff meeting, okay? God goodness. And then, you know, there are stress, as I said, stress-related injuries, the ergonomic keyboards, that might be important. Now, here's one other thing. Employers may require workers to change work environments for safety reasons. Well, I mean, how much control do you really have over somebody at home? Well, think about it though. If a worker told you, look, I'm working from home here, but I'm, you know, it's a studio and I'm in here with my, you know, sick spouse. Oh, okay, well, that might mean that you should at least try and put your desk at the far end of the room or something like that, you know, away from people who might expose you. Another thing I thought about is some people go and work in their garages. Well, you know, I had a childhood friend who died from carbon monoxide exposure when they were working in a garage. So, you know, that might be something you'd say to them, let's see if we can find you another place to work rather than that. Okay, let me see. I think those are the main things that we wanted to cover today. You know, want to make sure we got some questions here. Of course, there are many things we didn't cover in terms of what are exempt employees or a few other things on the COVID side. But let's see what we can do to answer some questions now. Desiree, you want to tee up a few? Mm-hmm.
Yeah, so we had a question come in from Bethany.
Mm-hmm.
So we were talking about part-time workers and worker classification status and workers' comp.
Mm-hmm.
So the question here, sorry, we're going back and forth. I was trying to clarify the question.
Mm-hmm.
So I said, is the question, how many hours are considered part-time? And she said, yeah, sure. Does she like that question too? So I just said that under 40 hours is less than full-time work and will be considered part-time, but an employer, of course, could choose to give their workers status of full-time with less than 40 hours.
Mm-hmm.
So 40 hours is generally what California law would consider as full-time, but you'll see a lot of places will say 30 hours will be considered full-time for them, and 30, you know, sometimes 32. It depends on the different laws and policies that could apply. So I talked about how, for example, with the Affordable Cares Act, 30 hours or more per week was considered a full-time employee. So, you know, different things will come about. And with COVID, you know, can't say generally, but yeah, as long as it's less than 40, we could say that they're part-time. And her question was of an employee who's working 2 hours a week. So she was wondering, like, would they have to be covered under workers' compensation? So, and stop me and change my answer if I'm wrong, but I was saying how, you know, all employees should be covered under workers' compensation. Independent contractors, since they're not an employee, they may waive workers' compensation. You know, it could be tricky if they're acting as an agent or something, whether they would have to be covered, I think. But generally, also if you have seasonal employees, they would have to be covered under that workers' compensation. And then I said we can address it more at this point of the workshop. So those are the outstanding questions right now. So Bill, if you could piggyback on that and give more information.
Oh, no, I think you wrapped that up pretty well, Desiree. Just
Okay.
Workers' comp is required, you know, even with 1 hour of employment, as I understand it. So yeah, now I guess what I would point out to you is a number of people are asking about, well, gee, what if my worker gets sick with COVID and they could sue me? Does that mean workers' comp would be used for a situation like this? And that the jury is still a little bit out right now, as I understand it. It's contemplated. I mean, it's certainly a workplace injury that you could get compensation for. It's just that the system, I don't think, has sort of really geared up to do that as yet. We're watching to see, you know, are there any lawsuits that are able to lift themselves out of the workers' comp procedures, because, you know, workers' comp is there basically so that an employee, you know, and employers and employees aren't, you know, constantly suing each other to, you know, to deal with potential injuries and stuff. I guess I would say we haven't seen yet an employer situation where the employer was just so reckless about not planning for COVID, or, saying to a worker, oh, well, you have to work in this small office with somebody who has COVID or something like that. If somebody is that kind of reckless, is what I'm wondering, might be sort of lifted out of workers' comp at some point, but I haven't seen it yet. So hopefully the workers' comp system will generally handle those kinds of things.
So
Actually, by the way, this makes me think of something that is a common question also that people have asked, which is, well, what if I had my employees all sign waivers, liability waivers or something like that? That is, well, for one thing, your employee doesn't really have the freedom to not sign that waiver. So it's probably not going to be that effective in court for an employee who didn't, who signed it and then, somehow got COVID, and then the employer says, oh, well, you got a liability waiver for me. However, customers, that's a different thing. Customers, what we're saying is that this is where you need to be clear with, everybody should be pretty clear about the way that COVID is transmitted. So, I wouldn't say that you have to have on the side of your store chapter and verse about how COVID is transferred. I would say instead, in a waiver, if you were trying to use a waiver, you talk about the specific ways that people are exposed. So for example, you're doing nails for somebody. This is where, you might have them sign a waiver that says, look, COVID-19, very infectious disease. It is transmitted through the air and through contact with people. During the time we're doing your nails, you're going to be exposed to me closely for 45 minutes. I'm going to be wearing a mask. I'm going to be wearing a plastic guard or something like this, but there's always a risk that will be insufficient. And so in that way, you put the person on notice about the specific kind of risk that they're taking in working with you. And that's going to be much more effective than just simply signing some sort of waiver that just said, I'm not responsible for COVID. We don't know if those waivers are really going to be that effective going forward.
So, back to the part-time workers, are there more generally any kinds of obligations that apply for part-time workers, or those that don't apply for part-time workers that do apply for full-time workers?
Well, let me think about that. Well, certainly the wage and hour, the hourly requirements, if you're not doing, overtime, or you're not doing 8 hours a day, that you don't have to worry about. The breaks, we did have a slide on the breaks. So if you're working a certain number of hours a day, then, these breaks, go back if you see the recording to that. I can pull that slide up if I need to. But there are still breaks usually required for at least for even part-time employees. I think it's after 4 hours, is it 5 hours? I have to remember what it is. But anyway, so those things are the ones I can think of the most. Certainly you don't have to give them health insurance. The health insurance option, if they are part-time, you do have to give them, as I understand under Obamacare, you do need to be giving them information about how to get insurance. And after 50 employees, that's where the employers have to pay in and start actually providing it. But for my understanding of it is it's only required for full-time employees.
And another question that came in says, I would like to have independent contractors for my bread route as I am expanding deliveries to retail stores. Would I need to use Uber Eats, or can I go with other options? So
yeah, you mean like a private delivery person? Yeah. Well, this is where it would probably be better for you if that person would qualify as what we would call an independent business. So a single person doing this for you who doesn't do it for anybody else, that's more suspect. But if the person is doing deliveries for a lot of different people and even has like their own business license, or they've registered as a business locally, or they have their own entity, which would be particularly great if you could find somebody that has formed an LLC or something like that, or does it in partnership with somebody. yeah, all of these things, remember, are sort of, how would I say it, pieces of evidence that are on the side of the scale that will say this is more like an independent contractor than an employee because what I just said, this is an independent business, it works for others, they do business to business type of activity, they have an entity. So as you can show those actual aspects as well, then you're going to be in better shape for misclassification claims later. Desiree, there's some other? Uh-oh.
Wait, someone just said something. Hi, this is my first employee. I would love some tips on the first steps to hiring someone. What legal forms do I need to fill out and have them fill out? Great.
Good question. Good question. So one thing to think about here is, already starting with some good records on things. I think Raphael, Raphael, remind us of those things you want to do with employees first.
Sure, yeah. So, I mean, the first thing is you want to make sure that you get recognized as an employer. So first thing is make sure you have the employer identification number and also register yourself with the California Employee Development Department. Good. So those are the first things for hiring anybody. In terms of the employee side of things, you want to make sure you get an I-9 form for them and make sure you also get a W-4 for them. Make sure that you give them a W-2 as well by January 31st. Anything else?
That
there's
whole list that we have there, and then the minimums, the interviewing, the application, checking your references, all those different things. Definitely do all the checklist things that we talked about there. But checking references. And then the offer letter. By the way, Raphael, do you have this part about the offer letter? Why wouldn't you use an employment contract in this situation? Yeah.
Ooh, I don't have a slide about that specifically.
Okay. Well, so the main thing with employment contracts is you only want to use those, contracted employment is to be used when you have somebody who's really key, like your CEO or something like that. Whereas generally you want to keep things in California called employment at will. So that means just that you can walk away from that relationship at any time for any legal reason, and they can walk away from that relationship at any time for any legal reason. You can't walk away from the relationship because, you don't like their religion or they're too old or something like that. But if you just don't like what they're doing, you can walk away from it as long as you use what's called an offer letter, which just basically says, look, I'm going to offer this employment to you under these terms. Do you understand? Sign here. Now we have an employment relationship here. It's not treated as a contract because anytime you add a contract, then you can only terminate somebody according to the terms of the contract.
I'm also blanking on myself whether this was fully covered on the point of the I-9 form. Yes, you have to collect this information, but there's nowhere that you need to submit it once you collect it. That's usually a question that comes up a lot.
Good point. Good point. And here's an important thing about I-9 forms is you have to ask it of everybody. You can't just sort of go, oh, okay, I think this person looks like, something. And also you can only ask them, can you fill out an I-9 form and provide documentation? That's all that you can say. You cannot be saying things like, oh, gee, do you have, now are you sure you're able to work in the US or something like, no, you can't do that. And of course, that same thing that you asked about documentation, again, you have to ask that of everyone. You can't say just for the people who are, saying to them, asking them that question. Okay.
Yeah, and I will also piggyback on that to say that some employers have gotten nervous with me before. They're like, oh, but how do I know whether the documentation is valid and legit? We're not expecting you to be an expert in government identification, so long as, it looks valid and the person is representing that this is true, you let them fill out their information. Now, if I have a daughter who I know does not have the status to work here, and she gives me something that looks very legit, but I know because she's my daughter that it's not real, you know, I cannot say that because it looked real, you know, I filled it out and I thought I was okay, because, you know, then there's a fraud there, you know.
Right,
So so long as it's an honest belief that the representation is correct,
Yeah, the idea is that you can't knowingly hire somebody, and this actually works for contractors too. And that's why, for example, if you are a contractor, you are undocumented, you know, that's fine, but I wouldn't tell people openly about it because they can't, once they know that you're undocumented, they can't hire you. But except, and here's the important thing for the self-employed, is if you formed a business yourself, you could earn profits from the business, because anybody can earn profits from a business. You don't have to have a right to work to earn profits from a business. So talk to us, because we're actually doing some trainings on this in the area here. If you don't have a right to work in the US, still you do have a right to form a company and earn profits from that company and contribute, you know, your expertise to the company as well in exchange for those profits. Okay, so just talk to us if that's something that you're interested in forming.
okay, so the last question I'll throw here is, does the business engaging an independent contractor supply both workers' compensation to the contractor and liability insurance? So this.
No, you don't have to do workers' comp for an independent contractor, but you should require them to have insurance to protect you. And in fact, it should even say something in your independent contractor agreement that they will indemnify you if something goes wrong with the work that they did. Great. Okay, well, thank you, folks. And Ruby, if there are people that need to talk with us office hour wise, we have 2 appointments that can start right after this workshop. You know, let us know if there's anybody that wants to.
Yes, we do.
Confidentially.
We do. I want to keep us on here. The person who has the next office hour slot, just stay on, and so that we can talk, and then have the other folks drop off.
Yeah, and then I should say that we do have office hours every week. You should know. Mondays, we've started these up again. Hooray. Oh, here we go. Loving Dog Training. Oh, yeah. Hi, Loving Dog Training. We haven't seen you for a while. Is there a second one that we have, Desiree, available?
I believe Ruby, can you tell us? I think the second slot is still open. So we have the 2:15 and now we have the 3:15 filled.
Okay. Well, what we're going to do is we're going to start
links.
it right now, which is, about 2 o'clock. So we'll do it 2 to 3 for the first one, and then 3 to 4 for the second one. And you should just know, everybody, that Mondays and Wednesdays from 11 to 2, okay, Mondays, Wednesdays, 11 to 2, just go on our website, which is that last slide that I had here. Let me just put that up again. Way to the end. Ooh, come here. Cover bend here. Here we go. Oh, here we go. Yeah. From this slide. Yes, present slide. Current slide. There we go. Yes, current slide. Come on. Here we go. Yeah. So if you go to our website here, www.law.berkeley.edu and /NBCLC, then you can sign up for these weekly office hours, 11 to 2. These are, confidential. How do we, that's here. Anyway, confidential conversations with you. Basically, you talk to a lawyer and a student for about an hour there. So just know that that's available any Monday, Wednesday, 11 to 2. Okay. All right.
Okay, thank you so much, everyone, for joining us. And thank you, Bill, for the
Sure. And Raphael, thanks for joining on that.
Absolutely. Yes. Great. Have a great day, everybody.
Okay.
Bye.
Bye.
So Loving Dog Training, she should come back to this link at 3 o'clock. Hopefully she remembered to do that. Okay, that's good. And Ruby, what we should probably do at this point is stop the recording. Did you record? I mean, I hope you recorded.